There's mixed opinion over who should pledge allegiance to the king in Canada. Now, traditionally, all Canadian elected officials have to be sworn in, and then once they are sworn in, then they take on their role in public office. But in 2022, the Quebec government passed Bill 4, which abolished the mandatory oath for members of the province's National Assembly. Now, Lawrence David is a constitutional litigator, professor of law at the University of Ottawa, and founder of the Public Interest Litigation Institute. And late last week, he submitted a lawsuit against Bill 4, arguing its unconstitutionality. And he joins us now on the line. Lawrence David, good afternoon. Welcome to the show and welcome to your hometown airwaves. Nice to speak with you.
Hi, Sabrina. It's a pleasure to be here with you and your audience.
Let's get into this here because Quebec passed this bill. This was back in 2022. Why are you pushing back on this now?
It's very simple, Sabrina. As you may know, there is a general provincial election scheduled in Quebec for October the 5th, 2026.
Yeah, coming very soon.
Yeah, and this will be the first general provincial election since Quebec adopted that bill. So after the election, the politicians elected to the National Assembly will be required to take the oath, except that under this law, they will not be doing so. And in our view, this causes significant problems.
Like what?
Well, in order to sit in the National Assembly, you have to take the oath. And if they do not do that, the votes that they cast in the National Assembly and all of the laws that will be passed by the National Assembly will have no legal effect because the people who voted on them were not entitled to legally sit in the National Assembly at all.
Okay, but do they have to take the oath because they passed Bill 4?
Right. So as a result of Bill 4, they will not be taking the oath.
Right.
And they believe that this is legal. Unfortunately, it is not because the Constitution says that any amendments to the Constitution that affect the office of the king or the lieutenant governor cannot be done unilaterally. Quebec enacted this law, but did not seek the unanimous consent of Parliament and the other provincial legislatures. So their law is unconstitutional. And by not taking the oath, the people who will be in the National Assembly will not be legally qualified to sit in there at all.
So then how did they get away with passing that bill if, like you say, it's not legal to do so?
Well, because in 2022, following the fall election in Quebec, all of the members, actually most of them, in fact, took the oath. And it's only when the Parti Québécois refused to take the oath that the government then passed the law to enable the Parti Québécois to then sit in the National Assembly. So there was no problem at that time. And unfortunately, there has not been any previous legal challenge that would have attacked the constitutionality of Quebec's law. But in our view, now is the time with the provincial election on the horizon. It is the opportune time for this challenge to be brought.
Okay, so Lawrence, is there a way, should the Quebec government have done it in a way where it could have been legal? What did they need to do to make it legal?
The only way that Quebec could proceed with this abolition of the oath is to seek the unanimous consent of Parliament, the 9 other provincial legislatures. So it cannot act on its own. It cannot just pass a law and say, okay, well, we're going to amend the Constitution the way that we want to. Unfortunately, the Constitution Act 1982 has very specific rules as to how the Constitution may be amended and what is the rule that applies depending on the amendment that a province or any other level of government wants to make.
Now, when the government, the province here in Quebec, when it passed this bill, it was a unanimous decision. It did not really spark a lot of debate. Do you think there is an appetite for this, to revive this and to fight this in court?
Well, I'm not sure there's an appetite because it is a very uncomfortable topic for many public office holders. And I suspect that this is why the government of Canada did not take the initiative to challenge Quebec's law. For example, the government of Canada could very well have sought a reference to the Supreme Court of Canada as it is entitled to do. So I believe there's a bit of discomfort there. But nevertheless, it is important that this legal issue be addressed because otherwise Quebec could, or any other province or government could say, well, we unilaterally want want to amend the Constitution to say, for example, exclude the application of the Canadian Charter of Rights and Freedoms. And I think everybody would be like, wait a second, you can't just do that. You have to follow the rules to amend the Constitution. So our challenge is not about monarchy versus republicanism. It's simply about, hey, if you want to amend the Constitution to abolish the oath, follow the rules. It's a really simple proposition at the end of the day. Another thing that I would add, Sabrina, is that this is not a question of Quebec bashing. I've heard that a lot, to be candid with you. It's not a question of Quebec bashing because our arguments apply to every province and to the Parliament of Canada. And if Parliament had sought to amend the oath unilaterally, my answer would have been exactly the same.
Right. So for you, it's about the slippery slope that this presents, or the can of worms that it's opening, where you're making a modification to something, and therefore what else could you modify?
Exactly. It is a massive slippery slope, and the slipperiest of them all, because we're talking about the Constitution, the basic rules of our society that place limits on governments and how they exercise their power. So we have to be vigilant, especially when other levels of government are not, for whatever reason, taking the initiative to put an end to that. Then it lies upon civil society to take the initiative and bring these issues before the courts, before the Quebec courts in this instance, to get legal clarification for the benefit of all Canadians and all governments.
Okay, so you've submitted the lawsuit. I mean, what happens now? As you know, when things kind of snake around through the courts, it can take a little bit of time. We're headed to the polls, and there will be an election in a couple of months from now. What's the timeline you're looking at here, Lawrence?
Right. So realistically speaking, this will take some time. Certainly the legal challenge will not be decided before the election. We're aware of that. And so what we're asking the court is, well, when they decide the case and should they rule in our favor, if the members of the National Assembly did not take the oath, well, any laws that they would have passed, the court will say that these laws are unconstitutional until the members of the National Assembly take the oath and pass the laws again. Because, again, if the members are not taking the oath, they're not legally qualified to be there, and the laws they would have passed would have no constitutional, no legal validity at all. And again, this is very important, not just theoretical, because think, the government passes laws affecting social security, benefits, roads, the environment, I mean, you name it. So if those laws don't have legal validity, it's going to impact Quebecers from every sector of the province, including my own family.
Is there a precedence for this? Has there ever been such a case like this before?
Well, there is a case called the Manitoba Language Rights Reference, where the government of Manitoba published its laws exclusively in English, and where they were supposed to do it in English and French, and the Supreme Court said that publishing the laws exclusively in English was unconstitutional, so they said all of your laws are invalid until you adopt them in both English and French.
Okay, so that is an example of something that has come up in the past. You mentioned the timeline. This will not change before the next election. So does that mean once everyone is elected, we will not see a swearing in here in Quebec?
Well, here's the thing. We timed our action with the hope that perhaps the politicians would have a sober second thought and think perhaps out of a measure of abundance of caution, we should actually take the oath, because if it turns out that we're wrong and that Mr. David is correct with his legal challenge, our laws may be impacted. So perhaps they will take the oath. But to be perfectly honest, based on the reaction I've seen from Quebec politicians in the media, it seems unlikely that they will, because the views have been that they are comfortable with the decision that they made. So it will be for the courts to determine and provide guidance.
Lawrence David, thank you so much for your time. Really appreciate it.
Thank you so much, Sabrina. Have a wonderful evening.
You too. Lawrence David, constitutional litigator, professor at the University of Ottawa, and he recently submitted a lawsuit against Quebec's Bill 4, calling for the province to reinstate the mandatory Pledge of Allegiance to the King in the National Assembly. Now, the Office of Quebec Justice Minister Simon Jolin Barrette told CBC News that it has taken note of the legal action and intends to defend the province's right to alter its own rules. Now, spokesperson Elisabeth Gosselin says that a very large majority of Quebecers reject the monarchy and that the change made respects the position of the Quebec nation, and they will continue to occupy the constitutional space that belongs to Quebec. That is the statement from the office of Simon Jolin Barrette. Climate anxiety